Hi everyone, my name is Eric Long and I am going to be discussing the religious discrimination aspect of the Civil Rights Act of 1964. I've recorded this a couple times and I'm sorry, I'm just a monotone person. There's no exciting way my voice can be changed or whatever, so just bear with me. I'm sure a lot of this is very familiar with you guys because a lot of the different Civil Rights Acts or forms of discrimination are found under the Civil Rights Act. So I'll try and give a different spin, and definitely we'll focus on religious discrimination. To get started, how exactly did religious discrimination become illegal in the hiring? And that was found in, as you might have guessed, in the Civil Rights Act of 1964, specifically Title VII, and even more specifically, it's found in Section 703. Now, how much religious discrimination there was prior to this, I'm not exactly sure, to be honest. I don't know. I don't think it'd be nearly as much as race or color, but it definitely was there, or else it wouldn't have been put in, or maybe the people who wrote the act were very privy to what could happen in the future. Regardless, it's there, and that's how it became a form of discrimination when it comes to employing people. Now, like I kind of mentioned, there's other forms found in this called that make it illegal to discriminate based on race and color, religion, which is what I'm talking about, sex, or national origin. Now, you might be thinking to yourself, man, this sounds familiar. Civil Rights Act 64, Title VII. Why does it sound so familiar? Well, aside from the fact that you guys are business law students and you're well aware of it, it's also been in the news recently because of the Department of Justice sending a letter to the North Carolina state in general. I don't know the details, but it is an important point because it illustrates some other aspects of the act. But essentially, they sent a letter to North Carolina saying they can't ban transgender people from choosing which bathroom they want to use, and they use actually Title VII of the Civil Rights Act. But that's a little beyond what I'm talking about, but it does help further on demonstrate different aspects of the act. And this picture here is President Johnson signed the act into law. It became a law. So Congress passed in 1964 with both the House of Representatives and the Senate voting yay on passing it, and it was passed on July 2nd. Now, a little interesting fact is that it wasn't enacted fully until the next year, so 1965, for many of the aspects, at least of what I've read of the Civil Rights Act, at least in Title VII. A couple other bits of information. The Senate passed it 73 to 27 vote, and the House of Representatives passed it 289 to 126. So it passed pretty overwhelmingly, and it was a bipartisan act. And then, like I mentioned before, Johnson signed it into law in the same year. And this little diagram just points out that there were three aspects that came together to make it a law: the separation of powers, checks and balances. It's all review, but it was a conjoined effort, like many laws are. So before this, were there similar civil rights acts? And from my research, it looked on any level, federal, state, local, and from what I could tell, and perhaps I was just too hasty, I couldn't find anything that was on the same level for at least religious discrimination. Now, that doesn't mean there weren't similar things out there that made various characteristics of a person as a hiring criteria counted as discrimination. But those normally came after the Act of 1964. So you could argue that there wasn't anything similar because there wasn't anything else in existence. And in fact, the Civil Rights Act was kind of the spearhead that began a lot of these discrimination acts. And I list a couple here: the Age Discrimination Act of 1975, Americans with Disability Act, Pregnancy Discrimination Act. There's a huge list, actually. The bibliography at the end contains probably, just roughly like 10 plus different discrimination acts, and I guess you could probably argue they all came from or spawned out of the Civil Rights Act. With that being said, there were a couple, if I remember right, that came into being before the Civil Rights Act. One of them was the Equal Pay Act, so it required equal pay. I don't know the details, but it's interesting that there really wasn't much before the Civil Rights Act of 1964. So it's a very landmark sort of law, and that's kind of what spawned a lot of these other things. So yes, there is no very exact correlation of this law to others at that time, but now there's many other things that have very similar reach as the Civil Rights Act that just had to come up because the Civil Rights Act didn't cover it. Is the Civil Rights Act governed? So we know the Congress passed it and Johnson signed it into law, but who exactly controls it? And as you are aware, there's various agencies within the government who are delegated power to operate and enforce these laws. So broadly, the Department of Justice is the one who oversees this. Kind of falls under their power, and hence why the Department of Justice sent the letter to North Carolina saying that they can't deny transgender people which bathroom they choose to go to, because that's their jurisdiction. However, in order to employ and enforce the act itself and the various other laws that have been passed in recent times, that is delegated to the Equal Employment Opportunity Commission, or EEOC, which is a division, as far as I understand, or below. It's part of the Department of Justice. So when you work with the EEOC, you are working with the Department of Justice ultimately, and that's who the governing body is, and that EEOC is actually just a commission of 5 members. And it's a bipartisan commission, so 5 members unequal, which means that there will either be 3 Democrats and 2 Republicans, or 2 Democrats and 3 Republicans running the party. However, you can't have more than that, so you can't have 5 Republicans and no Democrats, or 4 Republicans and 1 Democrat. Anyways, it's a bunch of language that it's supposed to be a bipartisan committee. The chairman of the commission is appointed by the president, and each member serves 5 years. So there's a good deal of work gone into it for the members of the commission. So exactly does the EEOC enforce the act? I mean, just because you're a governing body doesn't mean anything if you can't actually punish people for breaking the act. And essentially, the act gave the EEOC the power to work with any level of government to ensure employers are complying with the act. And this means that they can go with any level, the county, the state, local law enforcement agencies to make sure that different employers are abiding by the act. So it makes sense. There's no way the EEOC could somehow manage every single employer across the United States and make sure they are agreeing with the act. So it does require a little bit of work together. And as a little side point, a lot of times the EEOC is tipped off at practices that aren't in line with the act. So it's not as if even they are constantly going around and auditing different employers. That might happen, but it requires a lot of cooperation between different aspects. And when the EEOC has enough evidence of religious discrimination or any breaking of the Civil Rights Act, the Attorney General can then prosecute the employer, which thereby enforces the act, and it shows to other employers, hey, you can't just not follow the act. You gotta obey it, or else you will be prosecuted. So the EEOC does have power through the federal government. So an important point in how to apply the Civil Rights Act, and this applies to all of it, but like I said, I'll talk about the religious discrimination, is that the 14th Amendment is often used in conjunction with the Civil Rights Act. As will become evident, because the Civil Rights Act was for employers, it eventually extended to any sort of public realm, as far as I can tell, specifically, at least in the very least, realms of education. Same thing with the transgender bathroom issue. The Department of Justice was writing a letter to a university in North Carolina. I can't remember which one. I think it was North Carolina, saying they'll deny federal aid if they don't comply. So it seems to stem to educational institutions, as you will see in the case I present. But anyways, it requires the 14th Amendment, and that's even written into the act. And the 14th Amendment, as a refresher, is that all citizens of the U.S. shall receive equal protection of the law. So this is not some using the 14th Amendment is not some back way of the EEOC for the EEOC to prosecute various employers. It's there as a way of letting people properly use the anti-discrimination aspects of the Civil Rights Act in non-employer settings. As we Charlotte Hearn, she is a Muslim sixth grader at Oklahoma Elementary School, and she wore her hijab as a religious duty, and unfortunately the school saw it and classified it as a hat. School policy also said that hats aren't allowed to be worn in school. The problem is that it wasn't seen as a hat by her, and it was seen as a religious duty. And a little bit of background information: the school originally allowed it, then they didn't, then they suspended her, and then her parents prosecuted. It was denied, and as we'll talk later, the Attorney General wound up taking up the case under Title IX of the Civil Rights Act because it did fall under the religious discrimination. An important thing is, in the bottom here, it says the hijab is a critical part of her Islamic faith, and taking it off would cause a substantial burden to allow her to practice her faith. And in my eyes, in my words, I guess, it seems like she would much rather not wear it, but she has a higher obligation to practicing her Islamic faith and her own comfort. And I think that's a key distinction between just wearing a hat and wearing something because she's not forced to, I shouldn't, but she has to as a duty to her faith. Eventually the case was settled. Like most cases, you want to avoid the publicity, the costs, litigate, all that stuff. And the school was had allowed her to wear a hijab and throughout her whole time at the public school. And a provision was added to allow for sort of religious discrimination, or accommodation, I should say, for any future religious dress that might be required. Because up to that point, it wasn't written in, so it was hard to argue that it was religiously required. In addition, the school is required to go through training to be aware of this sort of situation in the future. So the case ended pretty well, and it was a victory for the Civil Rights Act, and like I said, it was found in the educational arena, which is a commonplace of the religious discrimination, much more so it seems than in the work environment. So with that said, though, discrimination, and the question is, well, how do I make sure we do it? And there's no exact answer. There's no formula that they must follow, and then they've sufficiently not discriminated based on religion. But in my eyes, it seems that the best answer is, one, to be well aware of the Civil Rights Act and what it means, and then on top of that, be aware of cases that were ruled on or for or against or whatever in relation to the religious discrimination. Just because the wording of the act seems clear, the interpretation of the courts might be a little more complicated than what the act itself says. So an important key to remember, and I'll cover kind of both sides, is that the employers must reasonably accommodate a religious requirement by an employee. That means that you can't just make a little half-hearted effort to help the person meet the religious accommodation. It has to be a good faith, full effort to make it work. And that doesn't, and the act isn't heartless. It understands that if it puts an undue burden on the employer, they're not required to go through on accommodating, and that obviously has to be proven through a variety of means and whatnot. But essentially, it has to have a good faith act on part of the employer for it to be exempted from that. On the flip side, the employee can't just claim religious discrimination for everything. It has to be a genuine and sincere faith, and not being able to practice that aspect would be an undue burden on themselves. example of like a bad use of it that would never fly, but it's just an example, is that perhaps someone claims religious discrimination because they're not given nights and weekends off, and they need a 7 to 3 schedule, and a variety of things. That's a little harder to prove versus something as genuine as in the Hearn case, Nashala Hearn, the one I just talked about. And then as an example too, it goes for the employee to be reasonable about their accommodation. So, for example, for myself, my family and I like to go to church on Saturday night. We go to a big church. There's 3 services, and it just works out better time-wise, and everything go on the Saturday night service. Well, I also occasionally have to work Saturday night. Could I claim religious discrimination? No, because there's many other services, and my obligation, understanding that I must work for my employer, that I have to give in and maybe make some compromises. So, yeah, it might be a bad example, but the point is there has to be give and take on both sides. And as something I think I'll take away from this class, the biggest thing is that there's 2 aspects to the law. There's the written part, the letter, and then there's the spirit. No one disagrees on the letter because we all read English, we know what it says, but it's the spirit of the law that takes time, and that's where lawyers come in, and I mean they come in a lot of places, but I think that's the big part. Is that understanding the letter of the spirit of the law, and in that case, there has to be give and take on both sides. So, with all that said, the employer must be willing. I just have the employer here must be willing to go out of their way to provide accommodation, but the employee likewise must be willing to understand that they have to make some adjustments. They have to do everything they can to make it work. And it's not only on the employer, and this is as far as I understand, to make it work. It requires a little give and take, and I think that's how a lot of these cases are figured out. So, I found most of these online, and they're pretty short reads and easy to navigate. So, I hope that explains religious discrimination under the Civil Rights Act, and I hope it gives a good overview, and I hope that it was slightly interesting. So, I appreciate you listening to this, and I will likely interact with you guys in the future.